So I think we have a few slides on the work that we have done. I think it covers most of the points that we have already. Won't take much time. Unfortunately, this is all about quantitative side of things. So, data. So yeah. So tracking laws using data. Yeah. This is the live stream, so it's a bit laggy. Yeah. So why do we need to track laws? Because, and this is all an assumption, it might lead to institutional accountability, identification of gaps and challenges in. There are a lot of departments involved. So where are the gaps? Our policy should be data driven. We need to do impact assessment of laws, which is usually missing. Efficient courts, and I think timely justice is all what we are all here for. So that is the objective. So using data to track child protection laws. I think Miguel sir already spoke about the NCRB, and that is in fact the only official data set. The Crime in India reports which are released by the NCRB annually, though not annually now. The latest one available is from 2020. Data sets are available, they are machine readable, so easy to interact with. Indicators though are aggregated at a police station level, but for on the website they only release state level and for a few metropolitan cities. For POCSO, NCRB started computing data from 2014 onwards. So 2012 and 2013, the methodology of capturing POCSO cases is very different from what it was from 2015. So POCSO, let's quickly see what POCSO related indicators in the NCRB. This is not an exhaustive list. So there are three categories. One, for persons arrested, you have arrested, charge sheeted, convicted, discharged, acquitted. Then you have these many indicators for the inputs. Cases on trial, cases awaited, disposed by plea bargaining, etc. So all of these indicators are available for courts. And then there are even more indicators for the police. I think the maximum for the police. So yeah, all these indicators are available. But then is data from NCRB enough to track laws? If there is nothing, then yes, it is important. But where it helps, as it's the only official source of crime statistics, and you can also understand patterns within a geography and over time, because the data is available, for a few years, and also within the same geography. So it helps in understanding the larger patterns of crime, even if you are not able to find hotspots within a city because that data is not available directly. And also another important thing is the data is available in Hindi and English, at least two languages. Where it doesn't help is there are frequent changes in the methodology for capturing data for indicators, which means that you can't always compare, it's sometimes apples and oranges. Exact methodology is not documented. Data obviously is not available. It's always most of the time it's delayed. District level data is very hard to procure. And so is the police station. Also, our colleague Samriddhi, she just went to one of the police stations in Bihar, and it was very difficult to get the data. Though it is, you can procure it, but then there is a lot of steps to take to do that, which is not clear at all. So apart from NCRB, then there are other data sources, and especially what we focused on for this report that we wrote with her. We use the data coming from the courts, e-courts, and we only were working with the district courts. So data maintained by courts is an important resource. So what is different when you compare it with NCRB? Granularity, because data is available for each case. Timelines, data is available on almost on a near real-time basis. Like I can get what happened yesterday in court. Coverage is also good now because mostly all the district courts are on the e-courts platform. Ease of access, I will say that if I have to look at my case, then I can go online and search. But if I have to, let's say download all the POCSO cases, then that is a very hard thing to do. So ease of access in terms of accessing this one case. And then there's also the e-committee is also trying to build other tools and resources so that people can interact with this data even if they're not able to download it. So platforms like the National Judicial Data Grid can be used to explore this data. So hence the data is there, the data is important, the volume is there. But then what are some of the challenges? As I said, accessing in bulk is difficult. It's very difficult because of a lot of data standardization issues, and it's like every district court has a department, and sometimes they follow these practices, sometimes not. It's if I have to see how many cases are registered within section 4 or 6 of the POCSO Act, it will take me at least with a lot of manual work. So a lot of these things are there. Yeah, exactly the point. Data sets. Now this is also important. Now there are at least Delhi High Court, there was an order that that the court should not upload judgments, POCSO judgments, because of sensitive information. But then a lot of information is available on the judgments, like about the victim, about the incident, victim compensation or sentencing for that matter. Now a lot of these things are not available if the judgment itself is not available. So then what is the midway? So yeah, so dealing with this, especially in POCSO cases, is very difficult. Data completeness, a lot of times, now it all depends on how the data is curated. Sometimes a lot of important fields are missing. And since things are getting digitized right now, so which means that let's say pre-2015 or pre-2014, the quality of data is not that good. Now, there are a lot of things that we can capture on records. Yeah. So this is a case on ePost. This is how it looks. So you have the case type, the filing number, filing date, registration number, CNR number, which is actually the ID of a case. Then you have case status, which is whether the case was disposed or it's pending. You have the petitioner and advocate details, you under what acts and sections. Now here is where it gets quite messy. Now this still is written in a proper format, like sections are separated by comma, but a lot of times it's a very messy data set. There are all sort of combinations which are present, and this is like a very important data field. So a lot of data, a lot of indicators are available, but then all depends on how good the quality of entering or curating this data is. So how we use data from ePost to track the POCSO Act in Assam. So we collaborate with the Hub Center for Child Rights to track POCSO in Assam, Delhi, and Haryana. This project was part of the grant that we received. So we participated in the Data for Justice Challenge, which was organized by partners at Assam. The main source of data for this research is cases coming from ePost from 2012 to I think March or April of 2020. There were a total of 19,783 cases across the 3 states. We had to download close to 1 lakh cases and then filtering it out and making sure that the data is correct. We kind of it filtered down to almost 20,000 cases, out of which almost 30% are from Assam. And in those 30% cases, or 46% were disposed, and 3,000 cases are pending. But this was during the time of data collection, which is April of 2020. And fortunately, here judgments were available in almost 42% of the disposed cases, so not that bad when we compare it to the national average. But still, this was a challenge to obtain judgments and orders. So now we just to give you a brief insight on this is like this is not a report, but just to see what all we had captured. When I put my screen is visible. Okay. So some basic indicators like total cases in each district and now cases pending, now where the cases were pending, and this is just for Assam. Cases pending under each category. Now, this is also important because some of these indicators are not available directly from NCRB. like I can still see cases registered under a particular section, let's say section 4 and 6 of POCSO, but in terms of pendency, I won't be able to get that information. But through eCodes, this information is available now. PSS stands for penetrative sexual assault. So these are some of the short forms that we use, and we are calculating pendency for each of the offense which is listed here. And obviously, we are using the primary offense logic that the NCRB also uses, which basically means that the offense with a higher punishment gets taken as the offense for a particular case. There are conviction rates by the type of offense. Again, with possible because the data was captured at this level. Time taken for disposal of a case, disposal time as per the nature of disposal, and the last one, this is a bit interesting. Reason was, I think, now even I think the Finance Commission has kind of supported that. I think the grant that they had, the 5,000 crores or 10,000 crores, most of it was to develop fast track courts across the country, and but then. There wasn't any logic shared in terms of where these courts should be built, or depends on the caseload and pendency and other things like why and where the fast track court is needed. So this is again a very simple logic. Now you see the total caseload, and this is for 2019 for all the districts. This is an increasing order, and then pendency percentage at the end of 2019. And you will see that it's very visible that there are some courts which have a lot of caseload, but they are also able to close cases quickly. Now, this is just the numbers. We don't know about the quality of how that is happening, but as per the numbers is concerned, there are good, like for example, Barpeta, the caseload is like very high, 353 cases in a year, but also the pendency is low, which means it's doing decent as compared to other.
Is the district on Kathiyati's statute?
Okay.
That's why.
Yeah. Yeah. That's a takeaway for today. So yeah. So I think when I was preparing this, I saw also the Kamrup Metro also has a very high pendency and very low disposal. Disposal rate is as low as 5%, or was 5% in 2019. And if you can see, it's I think 6th or 7th class. There are 215, so decent caseload, but very high pendency, like 95% cases were pending at the end of 2019. So based on this, this is a very basic analysis. A lot can be done, and but still shows the possibilities of when the data is available. Now what's next? Now a lot of these points are already discussed. The whole data is powerful, but it is limited. There are several aspects which Miguel sir talked about, which are difficult to understand, and proceeding, equity, conviction, bail, forensics, etc. Important indicators like time taken to file a charge sheet are not available. Just the date is available, but the time taken we don't know. Time taken from cognizance to completion of child's testimonies not captured. Reasons for adjournments not captured. No details mentioned around interim or final compensation to victims. The time it takes for court to grant, this is like a common thing across the country. It's not known. Other important indicators around shelter and witness protection support, medical support, paralegal support, etc., not captured. Which means we need more data and we need more indicators. Yeah, and data coming from police, which is by NCRB and courts, those are like very important components, but they don't tell the complete story. So so one of the plans was to kind of take this report to, let's say, the District Legal Services Authority or the Judicial Commissions or maybe other stakeholders who are involved, and look at their data systems and see, okay, can, like you had mentioned, how everything can be plugged together. So that is what we need. And this is also where we would like to get your feedback on, which is so at least how we are planning to take this side is the discussion with stakeholders on how this information can be used again. So we recently the E committee of the Supreme Court, they also came up with a consultation paper. So they are now working on the third phase of the third or fourth. So which is now it's hard to access data from equals, but then there was a plan on having open APIs, which means that everyone can, let's say if I want POCSO cases, I can probably just select it somewhere and I will get a bulk of cases to download. So that is the plan, but looking at the data quality, looks like it will take some time, but at least they're thinking in that direction. Collaborating with researchers to identify steps that can be taken by courts to share information related to POCSO cases without compromising anyone's identity. Now, this has been a challenge, especially if you would like to get access to judgments and orders. Now, it's not clear on whether the courts can share it or cannot share it. So as part of this study, we had collaborated with Macquarie University. So their students, they had research around how other countries are dealing with this problem. So, whether they have systems in place where if a researcher wants access to this data, then, what to do or how to protect privacy. So, at least what we have seen is that what some states have started doing is they anonymize the names, but still there is a lot of information present within these judgments. So, even we don't feel comfortable. We have the data, but we don't know whether we should have it or not. Who are we to have that contain the data? Finding ways to collaborate with child protection society, child protection commissions, legal aid authorities on enhancing their internal data capacity, which our hope is to improve the overall state of data. And all the data sets, obviously not the judgments, and also we have tried to anonymize these data sets the best we can. So the data sets are uploaded. So this is also a platform that we have created where so when you see, especially in the law and justice, this space, there isn't a lot of public data available, but then there are organizations who are collecting a lot of data on ground, victimization surveys, etc. So RTIs. So the intent behind creating the justice hub was for people to be able to share all this data at one place. So all the resources for the project are uploaded there. And yeah, I think we have discussed on both these questions and how can data help in understanding the gaps and challenges faced by stakeholders, and also how we all can support kind of each other for better tracking and monitoring of child protection legislation. So any last thoughts you have, sir?